Distinguished guests, ladies and gentlemen, we are back to the second sessions of the World Judicial Integrity Forums of 2026. And once again, I will be your moderator for these sessions. So in these second sessions, the topic that we are going to be focusing on is more advanced. We are talking about digital transformation of courts, innovation, cybersecurity, and access to justice. And we are honored to have the experts come from Sri Lanka, Malaysia, and also Brunei. So ladies, Philippines, sorry. Sri Lanka, Philippines, and Brunei. I am really sorry. And now, ladies and gentlemen, without further ado, I would like to invite Mr. Shanaka Gunasekara from Sri Lanka. He is the partner and head of data protection of privacy of FJ&G di Saram to give the opening remarks.
Good morning, everyone. Thank you for having me. And the topic is digital transformation of courts, innovation, cybersecurity, and access to justice. So we'll begin from innovation. I think we all know the court systems worldwide are not required.
Okay.
Court systems worldwide are slow in terms of adapting innovation. So we are in the era of artificial intelligence, which is basically generative AI, and how do we integrate this into the judicial system so that the efficiency can be increased. We all know the principle, justice delayed is justice denied. So unless we keep up with the technology, what happens is that the public trust that we all talked about will start slowly deteriorating. And it has, to a certain extent, worldwide, justice system has deteriorated in a way that because everybody believes if you go to court, the process is slow and the judgment will come at a much later date. So the need for integration of innovation into the judicial system is more critical than ever. So in the panel discussion, we will dwell into how the artificial intelligence can play a role there and the challenges that are there, especially the digital divide and the lack of infrastructure, which will prevent the innovation from being ruled out, because in a country where there's a judicial system, you need to address both the rural areas, developed areas, all together. So when you are addressing all the sectors of the economy, you cannot roll out the technology which is cutting edge without actually providing the infrastructure to the rural segment as well. So the innovation with the challenges, and how do we overcome those challenges? We'll have to delve into that. And then the cybersecurity. With the innovation in the digital sphere, the number one threat is the cybersecurity challenges. That means the hacking to the social engineering, all that would result in confidential information being lost or damaged. Say, for example, if it would be equivalent to burning down a court registry, the physical registry, to actually hack into a database and then ensure that the data is encrypted in a way that the evidence can no longer be retrieved. So cybersecurity, while adapting innovation, cybersecurity also needs to be maintained. As you all know, the cybersecurity is founded upon any information security system, I would say, is founded upon the CIA triad: confidentiality, integrity, and availability. So integrity is actually the part of the topic of this forum. And the integrity in the cyberspace practically means ensuring that the data is protected and it's also free from corruption, the data corruption. And so that cybersecurity aspect needs to be built in to the innovation steps that we are taking. That means ensuring that the information management system is continuously improved so that the challenges are identified, risk is analyzed, treatment options are found, and they are deployed and monitored, and the cycle should continue. So then the third aspect is access to justice. This is where the innovation and the bridging of the social inequalities needs to take place, because the more you drive towards innovation, the more issues of access to justice can arise. Because even if you have internet literacy, dealing with the e-court system is not an easy challenge. because even a person who has literacy would find difficult to deal with a sophisticated system. So the accessibility features, ensuring that the necessary training is provided, public awareness is provided, all that is required. That's, in addition to that, providing the infrastructure, ensuring that there is stable internet connections, ensuring that the power, there is no power outage during hearings. And if that happens, how do we ensure the session is progressed and defend the making available the resources, such as the break rooms for the client and lawyers to have discussions. All that becomes relevant, ensuring access to justice. And with that I think we can dwell into a discussion with my learned colleagues on the topic. Thank you.
Thank you very much for your wonderful remarks, Mr. Shanaka Gunasekara, partner and head of data protection and privacy of FJ&G Saram. And now I would like to invite our next panelist, Mr. Leland or Villadolid Jr. from Philippines, co-managing partner and senior partner of Angara, Abello, Concepcion, Regala, and Cruz law offices, to commence his remarks.
Hello. Yes, good morning, everybody. To start with, I'd like to introduce the word ugnayan. Ugnayan is a Filipino word which means connection between the people and its institutions. And this is one of the guiding principles of our Philippine Supreme Court in trying to use digital innovation on bridging this gap between people and the judicial institutions. So the reason why digital innovation became critical is the irony is that 95.8 million Filipinos out of a population of 117 million are actually media users. So the Philippines is one of the highest users of internet, and you have 98 million internet users and about 50% of households with internet. But again, the problem there is that you have areas that are in far-flung areas that don't have the required infrastructure to adequately bridge this gap between people who actually need access to courts through this access to courts. And that is the reason why our Supreme Court thought that you leverage digital innovation in order to bring justice to the people. Now, what else was the trigger that spurred our Supreme Court in furthering the advance of digital innovation in the country? One was the 2023 incident wherein there was a breach of the e-payment system of the judiciary. And the next one was the 2025 cyber attack, in which a number of government institutions were simultaneously attacked, were subjected to cyber attacks. The Supreme Court itself was subjected to 9 million DDoS attacks, but fortunately, all of these were they were successfully repelled by the cybersecurity systems of the Supreme Court. So, and because of this, what happened was the Supreme Court came out with a SPJI, which means Strategic Plans for Judicial Innovation. The 4 core principles of this SPJI was timely and fair justice, transparent and accountable justice, equal inclusive justice, with use of a technologically adaptive management. And that was supposed to be a 5-year plan which started in 2022 all the way up to 2027. And during that period, the following reforms were implemented. One was the e-court, which is a digital platform for electronic service of filing and service of summons. Then we also have remote hearing and equal access to law. Because of the problem of lack of the infrastructure, the idea was to bring justice to the people. So we have video conferencing buses that would go to remote areas wherein remote hearings could be conducted for the people. We have digitization of payments. And having established all these digital forms of innovation in providing justice or access to justice, the next question that needed to be tackled was, how do you now use AI with respect to the environment of providing access to justice? And we have three core principles that were established. Human in the loop, wherein it is always the human that has oversight over the AI. Human in command, final decision is always with the human, and human on the loop. From the beginning stage, from the development, adoption, and implementation, there will always be human intervention. So human in the loop, human in command, human on the loop. One of the AI software that is already in use in the Supreme Court is the use of scripting. This is wherein they use an AI-enabled software to transcript voice-to-text transcription. And this is used by all, it is mandated to be used by all court stenographers throughout the Philippines. When this was implemented in March 2026, you had a efficiency rate of 90% in terms of completion and speed of the transcription of the stenographic notes. Okay. Cybersecurity in the judiciary. Of course, one of the first things that we did was migrate data to the cloud because it ensures there's a disaster recovery system in place. It's easier to monitor. Then we have the secure platform. All courts were given the respective PJ365 accounts. This is the high-end enterprise version of Microsoft Office. And then, of course, we have constant cybersecurity training for personnel. You have what you call constantly monitoring and testing, like the Supreme Court has red, blue, and purple teams. The red team is tasked with constantly trying to infiltrate the system, the blue team to repel, and the purple team to monitor the interaction between the red and blue teams. So these are done. It's like sort of penetration testing that is done throughout the year to ensure that the cybersecurity systems of the judicial portal is safe. Now, the immediate results of the implementation of the innovations of the Supreme Court is that it has improved. Prior to the implementation of these innovations, we had an average inflow of 43,000 cases per month, a total of pending cases of 704,000. So this was pre-pandemic, but with the the early implementation of these judicial reforms, first-level courts have improved in terms of disposition from 53% to 60%. Second-level courts for 30 to 40%. Now, you know, this may seem low, but it is a good start because it's to ensure that the data is secure, and at the same time, you will see that there is a marked improvement in the disposition of cases. Okay. Significant improvements require holistic reform. The Supreme Court has started this way back in 2022, but you would also need a holistic approach in the sense that the digital technological infrastructure needs to be improved by So that improves coordination from the telecommunications companies. It will also need coordination with other branches of government, like the executive department, who is in charge of the Department of Justice and the Public Defender's Office, and of course also coordination with the Integrated Bar of the Philippines. Because you cannot just have the one aspect, meaning the judiciary, improving or providing all these technological innovations without having a similar approach or strategy from the part of the executive branch and the Integrated Bar of the Philippines. So that is it for my report. Thank you very much.
Thank you very much, Mr. Leland R. Villadolid, for providing us a very clear example of the frontier improvement as example from Philippines, from the judicial system with digitalization, with the concept that I haven't heard about, I think many people haven't heard about, such as Unagan, scriptics, and many more. And now I would like to invite Judge Hazarena Hurairah from Brunei Darussalam to deliver your opening remarks.
Assalamualaikum, good morning still. I come from the perspective, a twofold perspective. I'm a court administrator, so I'm involved in the implementation and execution of the digitalization of the courts, and I'm also a sitting judge. So I'm also coming from the perspective of a user of digital services. So I just wanted to quickly walk through our journey over the last 10 years. It wasn't something that we aspired to in Brunei, to have our system to be digitalized. It was really something that we thought was necessary. So in 2015, we embarked on our digital journey. It first started with the judiciary case management system. And it was really a system that was adopted from Malaysia. It was a Malaysian company that came in and built the system for us. And it really transformed the way we offered our services in court. And it wasn't just only criminal and civil cases. We rolled it out to all our court services, including marriages, probate, and bankruptcy. So this really was a fundamental shift in how we delivered court services. Phase 2 is where we implemented or pushed digitalization a bit more. So between 2015 to 2020, we implemented online hearings. And this really coincided with COVID. Because we had already had our files digitalized, 99% of our cases could be conducted online by the time COVID happened. We also made it mandatory for our registered users to file all court documents online, and all 3 levels, so from the lowest level up to the apex court, they all use the digital system. I'm not sure if it was the same cyber attack, but in 2025, Brunei also experienced a cyber attack. And because of that, we had to take our system down. It was something that we felt that to ensure that the confidence of the public was maintained, we didn't want the problem of information being leaked, so the whole system was taken down quite quickly. So technology may fail, but justice has to keep on prevailing. So what have we learned from this incident? First is resilience. If the system goes down, we must have a backup system to ensure that we can continue with operations. We now know, because of the influx of cybercrime threats, the system must be secure, and there must be governance to help ensure that it is a holistic approach, that it's not only the judiciary's problem, but it's also the government's problem. And then third is access to justice. We understand that a lot of people are still very unfamiliar with the use of technology, particularly litigants in person. They're still very important to us. So digitalization shouldn't be a barrier, but it really should help people access our system, our services. So resilience, I won't say too much on this, but basically what happened is because the system went down, we had to have a system that was semi-use of tech and still go back to a manual system. So really it was in preparation to ensure that when the system did come back on, we could then integrate all the files that had gone manual. Pillar 2, and this really was a response by our government when the use of AI started to really come in. The government reacted quite quickly. So we have a one government private cloud to ensure sovereignty of our data, and also mandatory security testing as well through the various government agencies as well. In the court system itself, we've also issued AI governance principles. So how our court users or the people in the judiciary will use AI responsibly. Pillar 3, access to justice. The system is designed to accommodate everyone. So people who are used to technology, who like technology, and people who don't necessarily are comfortable with technology. An example would be, by default, we do online hearings. But if a litigant feels that they're not comfortable with online hearings, they can always approach the registry and put in a request to have an in-person hearing. So it's still very flexible in Brunei. From 2025, we have now embarked on a 5-year project. We are looking now to a JCMS 2.0. We'll be extending our legal services. So services that weren't included in our first system will be rolled out. So this includes legal aid, admission of practitioners, enhanced automation, so people can key in information and the court forms or the court documents will be produced automatically for them. Data-driven decisions, so especially useful for me as a court administrator. KPIs can be generated based on data as well. And of course, we cannot forget the use of AI, and that will be integrated into our system. So the objective is always, it's the same, with or without technology. Justice should be efficient, secure, and accessible. And that's it for me.
Thank you very much, Judge Hazarena Hurairah from Brunei. As the acting chief registrar of the Intermediate Court Judge of the Supreme Court of Brunei Darussalam, for your immense details in your journey through court legislation, especially in cyber attack. And as we already discussed in the cyber attack issues, I would like to ask the question regarding the cyber attacks. In terms of your personal opinion, Mr. Shanaka, how court strengthen cybersecurity framework to protect sensitive judicial data and prevent system vulnerabilities?
Yes, thank you for that question. So in terms of protecting the digital information, I think a court system should follow the same approach that is taken by the private sector, because when it comes to cybersecurity, there are no two standards. International standards remains the same. Now say for example, in this part of the world, and it's internationally accepted, ISO 27001, which is Information Security Management System. So what does it provide for is basically that CIA triad, confidentiality, integrity, and availability. So around that, there is a framework that is developed. And the beauty of adapting a framework, whenever you are deploying cybersecurity measures, if you deploy an internationally accepted framework, the beauty of that is it's certifiable, meaning it's very easy to say I'm protected. But the members of the public, especially when the cyber attack takes place, and when the cyber attack takes place in other jurisdictions as well, they ask the question, how are we protected? You say we are protected, but how are we? The only way to do that is to go for a certification. And that's where the standards coming in. And they are if you look at the framework itself, the framework provides that there should be leadership and commitment, which is number one, especially in the public sector. What happens is sometimes it begins, but thereafter with the government changes, policy changes, it drops. But with a certification in, what happens is that each year there is a mandatory auditing that takes place. If you find non-conformities, what will happen is you lose the certification. Then immediately alarm bells goes off, because then the members of the public can perceive that the system is no longer secure. Then with the leadership and commitment, you begin with a risk assessment. That's the number one thing. It's easy to deploy technology and think you are secure, but the risk assessment. What are the risks? If I am to deploy artificial intelligence, and if a particular solution is selected, what are the risks that are involved? And a full-scale risk assessment, and based on the risk assessment, you need to develop a risk treatment plan. The risk treatment plan would then identify information security controls, people, organizational, technical, and otherwise. So all those controls will thereafter address each and every identified risk. Then you need to document it, a statement of applicability, and based on the statement of applicability, you deploy thereafter the security measures. But actually, prior to deploying it, each risk needs to be brought down to an acceptable level, which we call risk appetite. If the risk appetite is at an acceptable level only, you end up in deploying it. So that's why every technology needs to get tested in that way. So if the risk level is unacceptable, you cannot deploy it. It means that you are not saying no for the technology, but you are ensuring that until it is brought up to a particular level, you don't deploy it. So then once you do the risk treatment plan, and then when you deploy, the other key absolute thing is continuous monitoring. I think my learned colleague from Philippines, as well as the learned colleague from Brunei, both mentioned that with the cyber threats that is coming in, and my learned friend from Philippines mentioned the red team, blue team, purple team. That is where the monitoring, continuous monitoring, and then hardening of the systems. Because in the cyberspace, you have the white hackers, the black hat hackers, and the white hat hackers. So the same approach that is being used. So the continuous monitoring, and based on the continuous monitoring, it needs to go to the continual improvement, not continuous improvement, continual improvement, because continuous improvement suggests every second you are improving. In the properly structured information security management system, what you are expecting is gradual increment, meaning not every day, but you monitor, you figure out the solutions, then you improve, continually improve, and then the cycle continues. So it's a continuous cycle, there is no stoppage. If at any point of time there's a stoppage, then the system collapses, because you begin with a secured system, because the threat landscape continuously evolve. If you do not continue, the system become vulnerable. And that is why the certification again is important, because you cannot maintain a certification unless you continue with the cycle. I hope that adequately answers the question.
Yes, you really answered the question, and thank you very much. So you think we need to have a standard, the clear standard and the framework to have a certification. And thank you for the practical approach of how the certification framework should be. So it should be in international framework, right? The same or standard. You think like globally?
Yes, because let me give from private sector perspective. Now, with the GDPR came in, worldwide, if you have to provide services which involve processing of PII, then obviously the controller based in, let's say, European Union cannot come to Malaysia or Sri Lanka or Brunei or Philippines and figure out whether this person has an environment which is suitable for handling data. So what do they have to do? What they do is they say either I will come for an audit, which is not practical, or you provide me a certification. And that's where the standards got developed. So these independent standards like ISO 27001 SOC2, and then for the PIMS ISO 27701, all got developed to address those needs. So from a small company providing services to a large scale company, these standards are scalable and they are applicable to the private public sector as well. So when you follow a standard like that, let's say for example with the future there will need to be integration between judiciaries, especially mutual assistance in electronic documents. So you need to have APIs that are secure from both ends. So if the system now, say for example, we need to collect with Philippine system which seems to be far ahead of Sri Lanka at the moment. But at that point, Philippines needs to ascertain by linking any of these systems in mutual assistance, am I exposing my system to a threat? But if I have the certification, then immediately, as opposed to a red flag, what you have is a green flag. So then what you need to do is only limited level of penetration tests, limited level of security assessment, and also figure out in the auditing certificate what are the issues that have been raised. So interoperability, integration, all that can be achieved if there is a standardization.
Okay, thank you very much. It's very clear. And what about Mr. Leland perspective in cybersecurity framework to protect sensitive judicial data and prevent system vulnerabilities? Because in Philippines you have been attacked as well, right? So what is your perspective on this?
I think to be able to adequately prepare for this, there are certain truths that we need to recognize and accept. First is that black hackers will always be there to attempt to find out the defenses of these institutions. They may do so for money, just for fun, or just to be plainly disruptive, because that's what they do, these black hackers. White hatters, on the other hand, are the ones responsible for defending these institutions and sniffing out these black hackers. So it is not a fixed standard, or it constantly evolves or changes. Like for now, the current acceptable mantra is that right now it is the principle of zero trust cybersecurity, which means that in accessing the cyber framework of a company, you trust no one. You always assume, externally, internally, trust no one. And then the second principle is the principle of less privilege, which means that the least amount of privileges you give to a user, the better. In other words, instead of maximizing the user's privileges in a certain system, you scale it down to the least possible so that it reduces the exposure. Okay. Then the third is that the depth of each level has a depth of protection. In other words, each device, user, even the printers, endpoints, all of that have their respective multi-factor authentication, user access privileges, and all that. It's all combined. So it's redundant. There's always this redundancy. So again, but all these things, they're all now, what's applicable now. In the future, another, the black hacker will think of something better, and then we have to react accordingly.
Yeah, because I think in the future it might be even gray hacker, right? Sometimes black, sometimes white. So I think your zero trust is really working in this regard. So we have discussed regarding the cybersecurity framework, and now I would like to ask Judge Hazarena, in terms of managing digital evidence and online proceedings, how can court ensures the procedural fairness and due process?
Yes, I think technology is an enabler, but it's not the means to the end. So the basic principles of evidence still apply. Our Evidence Act wasn't amended that much to cater to digital evidence, except that we now accept certain forms of digital evidence. But the main principles are still the same. Admissibility, weight, those really are left to the judge. you, yeah.
Okay. So the judicial principle still needs to rest with the judge. So is it the same as in terms of, the balance between the efficiency gain from digitalization with the need for human judgment and judicial discretion?
Definitely. So I think when you talk about use of technology or digitalization, it's very much a linear process, a lot of numbers, a lot of zeros and ones. Yes, no algorithms. But when you talk about court proceedings, each case is distinct on its own facts. The way parties react are different from case to case. So those balancing the use of technology and the nuances of people is very important. I think you have to cater to both. And again, it comes to whether or not a person is comfortable with the use of technology or not. And it's very much a policy in Brunei that if you are not ready to take on board digital systems, we will still cater to you. So we have maintained a person at the registry or at the counters to assist our court users.
So do you have the standard as in terms of limitations of how far we can go in terms of digitalization using digital tools involving in the judgment and the procedure of the courts?
Yes. So we do have specific internal AI guidelines. And it does set out what you can and shouldn't use AI for. Obviously, when we're doing legal research or when lawyers bring us documents, they bring a lot of documents, and sometimes it's just not practical to go through thousands of volumes of documents. So AI can be used to summarize information for the judiciary. But ultimately, the decision has to come from the judge, and I don't think that is something that will ever change in the near future.
Yeah, because some of audience have really curious about AI judge, ideas. So you strictly thinking that the discretion and digital decision needs to come from a human being that have morals, ideas as a judge, right? So now I would like to ask all of you, all the panelists, in terms of digital inequalities, that how can judicial system address the issues of digital inequality and ensure equal access to justice for all users. But before that, maybe you can give us the example of how digital inequality manifests, when we apply AI or digital tools.
Okay. So if I take my country example, and the internet penetration is not at 100%. So we are at about, I would say, 51%. And so with that being the case, if you end up in deploying an e-court system, that you would immediately see certain part of the community would be left out. So the internet expansion is absolutely key. Even if you have the internet expansion, then comes the other challenge. That, I'll give the easiest example. So lawyers would say, I'm familiar with the Microsoft Word. But the moment they are asked to work from Microsoft Excel, they say, I'm not that much familiar with it. Because you may have the internet literacy, you may know how to use a particular software, social media, whatever, but when it comes to, when you are given a different platform, usability of that platform, the accessibility of that platform, that depends on how easy that can be perceived and how easily it can be used. So the digital divide there again can arise if the system is very sophisticated. So the system itself can give rise to digital divides. Then on the other side of it, you will have the infrastructure, other infrastructure. Say for example, if I want to be a witness and I am summoned to be a witness, if I don't have electronic device at my home, then there is a problem. Then, when you adopt security protocols, now one of the biggest things that you would see is many people use mobile phones. But how many of them actively update when there is a security patch coming in? Hardly anyone. So that is why in an enterprise environment you have the central push. But in a human society you can't do a central push. So let's say you have a device, it is up to the standard, but you haven't updated. You try to log in and the system deny you access because the security patch has not been applied and the system is detecting that as a security threat. So there is a clear knowledge gap, and even if once you update the knowledge, then how do we keep up with it? Because environment constantly changes. So the digital divide will always be a subject. But all what you can do is how do I minimize it? Never, you can have the absolutely brilliant goal of elimination, but it will only be a dream.
Okay. So we need to keep updating for the knowledge gap and capacity, and I think awareness of this, right? And infrastructure cooperate to create the equality. How about Mr. Leland, in your perspective?
Well, if you've seen earlier from my slide, there's really, if you look at it in terms of percentage, there's no digital inequality in terms of, because 85% of the population have access to internet. It's really more of educating, educating stakeholders and convincing them, convincing the lawyers, and for the lawyers to convince their respective clients of the importance of using these digital devices to be able to have more in law, rather than, if they can use their respective digital devices to do other things, because they're so active in the internet, doing all this social media and all that, then they should use that same zeal in being able to use their digital devices in order to have more in law.
Okay.
So it's a question of education and convincing stakeholders of the importance of using these digital devices and innovation in order for them to protect themselves by using the law.
Okay, so the stakeholders needs to be managed in terms of the inequalities. And how about you, Judge Hazarena?
I was thinking about this. Brunei is quite similar to Philippines. We've got a high internet penetration rate, over 90%, I think. So we don't have a problem in that sense, but maybe there might be a mismatch in the language. So coming from Brunei, my mother tongue is Malay, and English is usually the second language. But in the court system or in the civil courts, English is the first language. So often it's not so much about people not being comfortable with using technology. It's probably the language barrier and the fact that there needs to be a lot of translation and interpretation services. But now that I know Philippines uses script text, and I'm sure that it is able to catch different languages, I think it's definitely something that we could look into.
Okay, so you think about applying the same approach.
Just a correction. Right now, it's the system allows them to translate Tagalog. Yeah, but in the Philippines, you have a lot of dialects. But right now, principally, it's Filipino that can be used to translate to English.
So it's really effective in terms of the translation. And I'm curious by myself, like even the older generations in Philippines and Brunei are really into the digital tools that they are really using is in terms of law?
I've had litigants who are mature, so I would say over 60 years old, who have been quite comfortable with using online hearings. So it really hasn't been much of a barrier in Brunei to use technology. I mean, it's very easy nowadays. You just need to have the application turn on your phone and connect. So it's really not a problem.
It's like doing a carrot and stick to these older practitioners. And then when I'm referring to the older practitioners, that includes me, because you mandate it or require it during the mandatory continuing legal education, which you're required to secure every 3 years. So you just insert it as a requirement that you have to you have to know all these tools. Then you also need to educate judges. They also have to, because there are also judges who are resistant to all these digital innovations, they also have to undergo their respective judicial training programs to update them with all these tools.
So I agree with my learned colleagues, and I think as has been done in Brunei, if I have not misunderstood it, so up until a particular stage, a hybrid system will have to be maintained, because you can't leave out the rural community. And I completely agree with regard to the people who have the capability but not sort of like their resistance to adapt, then there has to be immediate push. You cannot have that attitude. You need to agree. And with regard now, say for example, I think we were having a discussion even on this particular topic among ourselves. I think in Philippines you have the mobile court system where to provide the correct. So now there are other countries also that have adapted. So that's another solution that is available, where the infrastructure is brought to the area, so that, and then obviously I believe there will be officers who are handling the kiosk and all that would be there. So that would again minimize the digital inequalities. So there are various tactics that are available. Obviously, as we mature, we may find different techniques, such as the mobile court system.
Okay, so we need a proactive approach, maybe in terms of the digital welfare, something like that, right? So now I want to move into the regards of the key challenges and how to solve the challenges in implementing e-filing system, virtual hearing, and digital case management platform. May I start with? Okay, Ms. Hazarena.
Yes. I think when we first embarked on our digital journey in 2015, cyber threats weren't really a big thing. It's not something that we necessarily thought of. But now, fast forward 10 years, it really is something that you have to consider. And because of that, we've got, I think in the last 5 years, at least 5 government organizations that look after different aspects of cybersecurity. Last year, we implemented the data protection order. We've also got an agency called Rangsit, who looks after the certification of any cybersecurity issues or threats. There's quite a few of them, and because they're still new, I'm not too versed in them, but really it has come as a holistic approach. And we have decided, because I know it's usually argued whether or not judiciaries should have their own cloud, or is it better to go with the big companies like Amazon and Google and subscribe to them, and Microsoft as well. But we've decided that to protect our security, we've gone for a government cloud system, so we maintain the sovereignty of our data.
Oh, okay.
Yeah, mine will just be brief. With respect to the Philippine judiciary, it adopted a hybrid approach. So it makes use of the cloud, and at the same time it has on-prem services to manage certain applications. The thinking is that at least not all the eggs are in one basket or are in the cloud. Okay. The second point is that traditionally you have the castle and moat mentality, where everything inside the castle is protected and everything to prevent outside. But that has already been discarded, because we know that attacks can come from both internal and external. So the applications, the cybersecurity measures implemented by our Supreme Court is the defense in depth. Defense in depth strategy means each device application has its own independent sets of cybersecurity measures. So it's layered and redundant. And it covers all. It covers the device, the endpoint, even the printer, anything that the user. So those are the things that are being done. And then on top of that, as I mentioned earlier, you have the constant monitoring and testing by the red, blue, and purple teams.
Okay.
Thank you.
in Sri
So,
Lanka?
from a Sri Lankan step, we are still at the inception. Basically, in 2021, with the COVID came in, we adopted emergency rules to allow proceedings conducted for urgent matters by way of digital hearings. And thereafter, in 2025, Sri Lankan judges, Supreme Court judges, and a team of professionals visited India because India has made quite advancement in terms of the digitizing their judicial system, and they are actually in the process of setting up national judicial data grid. And with that knowledge borrowed from India, we have also launched the e-court project, where we recently the Supreme Court conducted the very first full digital hearing. And in terms of challenges and how to overcome them, it's still a journey that they are looking at. Because as we roll out, they will have to end up in ensuring that the system is protected. So that is where I actually advocate and as well as argue in Sri Lanka, it has to be standardized. Because at the end of the day, otherwise it's about them saying, okay, I follow these particular set of protocols. Now, my learned colleagues pointed out very clearly that the challenge landscape evolves. So when the challenge landscape evolves, unless you standardize, they say, for example, now he pointed out zero trust doctrine and the access controls. So all of them are controls, principal controls. But how you adapt them, the content of it needs to evolve. So that's why when you standardize, unless, let's say, your encryption level increase to that level, you don't get the certification. I'll give a very simple example. Now, olden days, 6-digit password was enough. Now the current recommendation, 12 characters, again is a combination. So unless you evolve your password policy in that particular way, you will not be able to keep up with the security. So you can have endpoint security, you can have all access controls right now. The moment the challenge comes, you have to change the landscape again. So that is why standardization is actually the number one thing I would advocate for.
Yes, even though the countries have, different backgrounds and capabilities, you still believe that we need to have a certain standard that is the same, right?
Well, I think it's a sort of a misunderstanding in that way. Standardization in the sense following a standard framework. Say, for example, the ISO, if you take the ISO itself, it has 92 controls. So all the 92 controls, it does not say that for the encryption this is the encryption 256-bit or 128. What it says is encryption. And then you have to actually do a risk assessment of your organization and figure out what is the level of risk encryption that we need to have. So that's what it means by standardization. You follow a framework. You have a goal, you follow a framework, and then implement based on your risk. That's what it means. It doesn't mean that everybody have 12 digits password. It simply means you need to have a password policy appropriate to the risk that you have undertaken.
That's very clear. So, because the time is up, so if any audience have any question, maybe we could ask after the sessions to our panelists today. So I have to conclude these sessions and then hand back the stage to Mr. Thanuwatt. Thank you.
Thank you very much. This could be a very, very fruitful discussion once again for the second panel. So in this case, I would like to ask Dato Sri Dr. Mohammad Nizam Shari, Honorary Advisor of the International Strategy Institute, on the stage to provide a token of appreciation to our panelists. Please have the photo groups together.